Hi, welcome back to DFC 2423 Cyber Laws and Ethics. So, this is our first chapters on Malaysian law. Okay, so before we start, okay, let's take a look what we are going to cover in this chapter 1, okay, Malaysian law. So, this is the subtopics. Okay, so in this chapter, we are going to cover generally on a few act. Okay, on a few act. For example, here we have Communications and Multimedia Acts in 1998, CMA, Computer Crime Act, CCA, Optical Disc Act, Digital Signatures Act, Telemedicines Act, E-Commerce Act, and PDPA, okay, Personal Data and Personal Protections Act. Okay, let's take a look at the outcomes. So at the end of this chapter, okay, you should be able to explain the key law governing cyber activities in Malaysia. Okay, so what is actually learning outcome? Learning outcomes means what you will gain, okay, at the end of this chapter. Okay, habis the chapters ni, you sepatutnya able to explain what are the law governing cyber activities in Malaysia. Okay, and the second outcomes is you are able to analyze the implications of this law on digital communications. And the last outcomes is you should be able to identify the regulatory framework established by Malaysian legislations. Okay, so let's start with ethics versus law. Okay, etika versus undang-undang. So what is the difference between ethics and law? So let's compare the both. Okay, so ethics is, in terms of definition, ethics is refers to a guide for computer user. It is a guideline, panduan for computer user. Okay, law is a rules for computer user. Beza tak sama. Okay. Ethic is a guideline, panduan. Okay. While law is a rules. Okay. Satu undang-undang for computers users. Okay. So let's take a look more differences between both. Okay. So ethics is free to practice. Free to practice. You boleh guna. Okay. You tak nak guna pun tak apa. Okay. Law must be practiced. You mesti wajib guna. Okay. Ethics are used all over the country. Okay. Etika digunakan dalam semua satu dunia. Okay. While law is depends on a country. Lain country, lain negara, lain dia punya law dia punya undang-undang dia. Okay. But what happened? What happened if you are not following? If you are not practicing the ethic? Apa jadi kalau you tak apply, you tak guna these kinds of ethics? You tak follow, apa jadi? Adakah you are being punished? Tak. You will not being punished. Okay? If you are not following, if you're not practicing the ethics. But there is a punishment if you are not follow ataupun if you're not practicing the law. Okay? Ethics non-compliance is called immoral. Okay? Kalau you tak comply, kalau you tak follow the ethic, okay, you tak practice the ethic, kita akan panggil you sebagai immoral, tak ada moral. Tapi kalau you are not compliant to the law, kita tak panggil you tak ada moral. Kita akan panggil you a criminal. Ingat tu. Okay, so this is the difference between ethics and law. Okay, so what is law in a definition? Law is a bodies of enforcement rules governing relationships among individuals and between individuals and their societies. Okay, so bila sebut laws tu kita apply di mana? Antara individuals tu, among individuals, and so do with between individuals and the societies itself. Okay, so itu adalah law, the definitions of law. Okay, so let's take a look the classification of law. category of law. Apa jenis-jenis law yang kita ada? So generally, secara generalnya, we have two classifications of law. First, that we call a substantive law and procedural law. The first classification, substantive law and procedural law. And the second classifications of law is private and public law. Okay, so what is substantive law and procedural law? Okay, kita tengok definition dia. Substantive law is a law that describe, okay, regulates, creates legal rights and obligation. Okay, substantive law ni adalah satu undang-undang yang dicipta, okay, yang define, okay, yang describe, okay, yang create dia punya legal rights and obligation. Itu substantive law. Procedural law, okay, is a law that establish the method of enforcing. Okay, kita ada substantive law. Substantive law ni adalah undang-undang yang mentakrifkan, yang menerangkan, mengawaslia, mewujudkan. Dia create that law. Tapi procedural law ni adalah dia define, tugas dia adalah dia define cara nak enforce the law create by substantive law. Okay, dia nak define apa kaedah untuk nak kuatkuasakan undang-undang yang telah ditetapkan oleh substantive law tadi tu. Itu procedural law. Itu dia punya kaitan dia. Substantive law, dia cipta undang-undang tu. Okay, so siapa yang nak enforce, nak kuatkuasakan undang-undang tu? Procedural law. Okay, alright. Second classifications of law is private law and public law. Okay, so what is private law? Private, bila sebut private, I think you faham lah. Okay, it governs relationships between one individual with another individual. Itu kita panggil private law. Okay, dia punya relationships antara individual and individual. Okay, so the main goals of this private law is actually to claim for compensation, tuntut pampasan. Okay, tuntut pampasan hak penjagaan anak contoh. Okay, apa lagi? Harta pusaka sebagai contoh. Okay, itu adalah private law. Okay, next kita tengok public law. Okay, so you know that private law it govern relationships between individuals and another individual. Okay, so how about public law? Public law it also govern relationships but between individuals and society. Banyak, okay? Individuals and society. So the main goals of public law is to punish the wrongdoer. Okay, nak hukum pensyarah pula, nak hukum pesalah. Okay, kalau private law dia lebih kepada nak claim for compensation, tuntut pampasan. Okay, hak penjagaan anak, hak itu, hak ini, tuntutan harta pusaka, itu private law. Kalau public law, dia punya kaitan dia antara individu dan juga society. Okay? So seorang individu ni mencuri barang di kedai runcit. Okay? So yang mencuri tu is considered as individual. Okay? Yang dicuri tu is considered as a society. Okay? So this case dia akan jatuh under public law. Okay, so yang mencuri tu will be punished. Okay, akan dihukum lah, right? Okay, so next we have another classifications of law which is traditional law and cyber law. Okay, so what is the difference between both? Apa tu traditional law? Okay, so traditional law is categorized as a law that already exists, dah wujud. Okay, traditional, dah wujud. Ataupun kita panggil dia offline punya law lah. Okay, so this traditional law was created not for cyber purposes. Okay, bukannya untuk cyber crime, bukannya untuk cyber purpose, but coincidentally appropriate and relevant to be adopted for the implementation, enforcement, and monitoring of crime in the cyber world. Okay, traditional law, it is not being created for purposes, but boleh diguna pakai untuk cyber crime. Okay, tak ada masalah, traditional law. So we have a few examples of traditional law, okay, which is applied to cybercrime. So we have a penal code, okay, copyright act, internal security act, what else? Official secret act, akta rahsia rasmi, sedition act, and so on. Okay, so all these traditional law, okay, all these traditional law are applicable to cyber crime. Okay, boleh diguna pakai untuk cyber crime. Tak ada masalah. Okay, and then we have cyber law. And please remember that cyber law is not a classification of law. Dia bukannya bawah kategori substantive and procedural law ataupun public and private law. Okay, it is actually an informal term, okay, satu term yang kita guna untuk describe, okay, how traditional law, okay, traditional law such as civil law and criminal law are being applied to online activities. Okay, cyber law ni bukannya satu satu classification of law, tak. Okay, dia adalah satu informal term, terms yang kita guna pakai untuk nak define traditional law. Traditional law, contoh traditional law kita ada civil law, criminal law, okay. Tapi this kind of law are being applied to online activities. Itu cyber law. Okay. Alright. So examples, okay, example of act, akta yang kita guna dalam cyber law. We have copyright act, okay, digital signature act, computer crime act, and many more. Okay. Alright. Kita tengok satu contoh. Okay, for example here, cyberspace contracting. Okay, contracting. Alright, for example kan, okay, awak nak create satu website, okay, so awak nak ada satu domain name pada website tu. For example www.akma.edu.my, for example. So, untuk nak dapatkan those domain names tu, you have to buy that domain name. Kena beli that domain name from satu organized body, satu organizations lah, okay, yang provide that domain name. Okay, so bila you beli that name, okay, that name together with website punya platforms tu, you have to sign up for a cyberspace contracting. Kena sign contract that we call as cyberspace contract. Okay, so this cyberspace contracting dijatuh under law of contract. Okay, law of contract. So this law of contract, dia punya perjanjian tu, okay, is refers to a private law. Kenapa? Kenapa private law? Kenapa bukan public law? Sebab apa? Perjanjian tu antara you dan juga pihak yang tersebut, pihak yang mengeluarkan, yang menjual servis tersebut. Okay, that's why dia jatuh under private law. Okay, and then second example, cyber terrorism. Okay, contoh phishing attack, bukan memancing tu, okay, phishing attack. Apa lagi contoh? Kita ada hacking. Okay, kita punya account bank being hacked, for example. Okay, so this is what we call cyber terrorism. Okay, so this kind of terrorism is falls into criminal law. Jenayah lah, satu kesalahan jenayah sebab dia hacking, dia hack. Okay? Dia mengambil data-data pengguna. So bila dia masuk under criminal law, dia bukannya private law. Okay, dia dah jadi satu isu jenayah. So this cyber terrorism is known as public law. Okay, alright. Okay, next let's take a look on Malaysian Act. Okay, akta-akta yang ada dalam Malaysia. Okay, so what is Malaysian Act? Apa tu Malaysian Act? Act, what is Act? Act it refers to a specific piece of legislation or law that has been passed by Malaysian Parliament. Okay, akta. Akta ni adalah satu undang-undang lah. Okay, undang-undang yang dicipta dan undang-undang tu dah diluluskan oleh Parlimen Malaysia. Okay, so itu yang kita rujuk sebagai Akta Act. So we have a few types of act, okay, a few types of Akta. Okay, first what we call as CMA. So CMA stand for Communications and Multimedia Act 1998. Akta Komunikasi and Multimedia 1998. Okay, ataupun also known as Akta 588. So this is example lah. Ini adalah satu contoh publisher which keluarkan Akta Komunikasi and Multimedia Handbook. Okay, so this is an akta. Dalam tu you boleh baca, boleh rujuk apa dia punya contents dia. Okay, so apa yang ada dalam Akta Komunikasi and Multimedia ni? Apa tadi? CMA, okay, Communication and Multimedia Act 1998. So CMA, it is actually established the legal framework for converging communications and multimedia industry in Malaysia. So apa yang dia covers? Apa yang CMA covers? So it covers a broad range of services including broadcasting, anything regarding broadcasting, telecommunication, online services. So this range of services are under ataupun are covered under CMA, Communication and Multimedia Act. Okay, alright. Kita ambil one example of punishment, okay, included in this act, okay, which is sections 233 kurungan 2 kurungan A, okay. So section 2332 kurungan 2 kurungan A provides for maximum fines of 50,000 RM or imprisons for up to 1 years or both. Okay, this is examples of cases, the real cases yang pernah berlaku dekat Malaysia, which is Tajo Zairi Tajuddin. Okay, so he is a bank clerk, Kerani Bank. Okay, so he is the first individual convicted of using pornographic applications over the internet for commercial purposes. So he create a commercial, a website. Okay, he create a website, a pornographic website, which is known as wanitamelayu.com. Okay, he is the first individual who is using pornographic application over the internet, which is considered as a cyber crime. Okay, which is considered as cyber crime. So these cases falls under section 233 bracket 2 bracket A. Okay, for provides for maximum fines of 50,000 K, 50K, 50K RM or imprisons for up to 1 year or both. Okay, so second examples of cases, okay, which falls under punishment sections 233 kurungan 2 kurungan A, okay, is the issues of Raja Petra Kamarudin, who was charged with seditions in connection with an articles in Malaysia Today. Okay, dia keluarkan satu apa isu yang berkaitan dengan unsur-unsur fitnah berkaitan dengan let's send the Altantuya murderers to hells. Dikeluarkan these kinds of articles on 25th of April 2008. So this is considered as cybercrime. So he's being punished under section 233 bracket 2 bracket A. Okay. Alright. Okay, let's continue with our second act, which is Computer Crime Act. Okay, second act is Computer Crime Act, Akta Jenayah Komputer 1997, or also known as Akta 563. So this is the act, okay, which is published by MDC Publishers Sdn Bhd. there's a varieties of act books tu, ke buku tu ada banyak jenis. It depends on the publishers lah. Okay, so this act is actually related to the offence of computer misuse, akta jenayah komputer. So akta ni dia berkaitan dengan kesalahan penyalahgunaan komputer lah. Okay, penyalahgunaan komputer for the purpose of committing a crime. Okay, so under this act, any unauthorized access, any altering any programs of data found in computers is actually wrong, okay, and can be punished. Okay, kalau you involve dalam satu organisation, for example, kalau you involve, you apa trying to access any kinds of program, any kinds of data in a computer, and you are trying to alter all the program or data, so you will be punished under this act, Akta Jenayah Computers. Okay, so this act is also effective for any crime committed outside Malaysia, even if the offence is committed by a person from a place, okay, outside Malaysia, as long as the computer or the program or the data is in Malaysia. Okay, kalau you berada di, for example, you berada di, okay, so if kita kata ambil example, let's say you berada di Australia, for example, you berada di Australia and you are trying to reach computer, to reach a program, okay, you are trying to access the data and data tu berada di komputer di Malaysia. Okay, so even though you are outside of Malaysia, you will be charged under Computer Crime Act. Okay, because you are accessing the computers in Malaysia. Okay, alright. So kita tengok example. What are the types of offences yang ada dalam this Computer Crime Act? Okay, this is just a few types that I keluarkan daripada akta ni. So first is Section 3. Okay, Section 3 Computer Crime Act, unauthorized access to computer materials. So these kinds of offences, if you are being charged under Section 3, unauthorized access to computer material, so the punishment is you will be fined not exceeding 50,000 RMs, or you will be imprisonment for a term not exceeding 5 years, or both lah. Okay, so itu kalau you just trying, okay, to access the computer material. Okay, under Section 4, unauthorized access with intent to commit further offences. Ini you have that unauthorized access, you access to that computers, to that data, okay, but with intent to commit further offences, you berniat nak apa nak merosakkan lagi, okay, so the punishment is a fine, tak mahal, okay, not exceeding 150k RM, or you might be imprisonment for a term not exceeding 10 years, or both lah. Okay, and the fifth, okay, sections 5, okay, section 5 Computer Crime Act, okay, describes that unauthorized modifications of computer content, unauthorized modification. Okay, section 4, you just have the unauthorized access, but with the intent, you baru berniat. Berniat pun you dah kena punishment. Okay, but if you have that unauthorized access plus the modifications of computer content, you might be punished with a fine of not exceeding 100k, or imprisonment for terms of not exceeding 7 years, or both. Okay, and another type of offence, okay, under Computer Crime Act, we have section 6, which is improper communication. Be careful with your communications, okay, over the internet. So improper communications, you will be punished a fine of not exceeding 25k rm or imprisonment for a terms not exceeding 3 years or both. Okay. Number 7. Okay, section 7. Okay, I have gathered another two types of offences. Okay, section 7.